Sahag, you may present your argument.
Mr. Chief Justice, and may it please the court. My name is Matthew Sahag of Dickey and Campbell Law Firm from Des Moines, Iowa. And I am here today on behalf of the appellants in this case, Dylan Clark, Zarpka Green, Agnes DeSabi, Musa Ezrig, Abraham Tarpe, and Dusty Neone, who are asking this court to reverse the district court's dismissal of their claims for negligent inspection and failure to inspect against the insurance company of the state of Pennsylvania for the following reasons. First, the district court was incorrect to apply a rational basis standard to the appellant's equal protection argument. Second, the district court incorrectly denied the appellant's inalienable right, which is access to the court system, by reading insurance companies into Chapter 85, otherwise known as Iowa's Workers' Compensation Scheme. And third, the district court incorrectly denied appellant's due process argument.
Let me ask you some questions about number 2 in
Sure.
your list there. There's a lot of talk in the briefing about the grand bargain of workers' compensation. And in short, the employer gives up various defenses and so forth, but in exchange, some of the common law rights that a worker would otherwise have are surrendered. That you're familiar with the general argument. There are cases out there that basically say, well, a workers' comp insurer basically stands in the same shoes as the employer, and various terms are used. I mean, sometimes it's called alter ego, and sometimes it's the same enterprise and whatever. I'm not too worried about the nomenclature, but the point is, if you look at the workers' comp scheme generally, the workers' comp insurer comes in and pays claims, is liable to pay claims, and does do these inspections, but these inspections really ought to be considered part of the workers' comp scheme as a whole. And you ought to pry this out of workers' comp. But from a functional viewpoint, at least, regardless of the numbers in the statute, I mean, one is 517.5, I guess, oops, I'm getting excited here. From a functional viewpoint, the insurer and the employer are kind of joined at the hip, aren't they? And if they are, then the rational basis test is probably the right one.
Well, I think while functionally or pragmatically that may be the case, that they work together, I think the more appropriate question is substantively, what was that bargain all about? And we see the bargain that's included in 8520 was about giving employers absolute immunity, co-employees qualified immunity, and third parties no immunity. The insurance company substantively is a third party. They're not the employer, they're not a co-employee. In fact, they would have a separate contract of insurance with the employer that would serve the basis as what are the terms and conditions of that relationship. And so I think the more appropriate question is, substantively, they're a third party.
Well, they are, I mean, they're a separate entity, no question about that. But I think the argument is, well, they come in and the insurance company, that is, the workers' comp insurance company, basically agrees to pay the benefits of a workers' comp claim, and indeed can be sued for the benefits, I believe. If I make an error, please correct me. So the workers' comp insurer comes in and kind of stands in the shoes of the employer, according to some of the cases I looked at least, stands in the shoes of the employer, pays the claim, and does these inspections really as kind of, some of the cases say alter ego of the employer, and I'll just characterize it as that. In short, the cases suggest that you can't blast the workers' comp insurer out of the bargain, if you will, of workers' comp. Again, I invite you to push back.
I can't point myself and just doing and thinking about the research that I've done. I can't point to any of those specific cases that do stand for that proposition. But again, I think, one of the things that you had mentioned is that you can sue a carrier for benefits. I mean, I think that goes to the nature of the relationship between the employer and the insurance company again, because you have a cause of action against an insurance carrier for potentially bad faith, whereas against an employer, you simply do not have a cause of action against the employer under 8520.
What if we took the situation where the employer had a safety supervisor, and the safety supervisor did the inspection? Would you agree with me that the employee would not have a cause of action against the safety supervisor unless you can prove gross negligence?
Unless you could prove gross negligence, yes, 8520 gives co-employees.
Now let's take it a step further. What happens if the insurance company, instead of doing a safety inspection on their own, gave the company a checklist to go through all these matters, and the company employer did the inspection answering this checklist? Can you sue the insurance company just because they gave them the checklist?
Well, under 517.5, you couldn't sue the insurance company, I presume, because they would be saying they're immune from liability based on 517.5. But I think you would look under that hypothetical, whichever employee was ticking off the boxes of that checklist.
Gross negligence.
Gross
again.
negligence.
See, the thing that bothers me about your position is that the statutes say when you can sue the insurance company, when you can't, because they're basically a party to the comp claim. And I don't know if it's because the commissioner wants to know that there's insurance there, because they're self-insured, you don't name the insurance company. And we have the other statute saying you can't sue them for inspection after fabricious, but it seems to me that how do you separate them from the employer in a workers' compensation situation? And I mean, you could say they're a third party. I mean, sure, they're a third party, but how do you actually separate them out from doing the duties that an employer probably should have done anyway?
Well, I think one of the things you do is you look, the way you separate them out is you look to the unambiguous language in 8520. And 8520 says that is ambiguous to the respect what it says. You can't maintain a cause of action against any of the following. One is an employee's employer. It doesn't say an employee's employer and insurance company. And so you would have to read the insurance company into the statute, something that I don't think the court would be willing to do based on statutory construction principles. So I think that's how you can separate them out. The other thing I would note is that one of the issues in this case is, under the appellant's equal protection argument, is this issue of whether or not there's been an appropriate suspect classification named. And in that regard, if the insurance carriers are a part of this grand bargain, then the insurance company sort of walks itself back into a different equal protection argument, because under 8520, third parties have no immunity, and yet under 517.5, the insurance company has absolute immunity. And so if that's the case, if they're a part of the grand bargain, which we don't think that they are, then you've got the situation where plaintiffs can't sue third parties who are private insurance carriers, and yet other plaintiffs can sue any third party who has no immunity under the statute.
But I'm not sure I follow, because the rationale would be, I think, that the insurer basically stands in the shoes of the employer. And the employer, so to the extent you can, the insurer enjoys the same protections of Chapter 8520 that the employer enjoys, period. And is that problematic? I mean, I'm fearing you're tearing down the whole 8520 structure.
I'm not tearing down the 8520 structure, I'm trying to tear down 517.5. And I don't think that the insurance carrier enjoys the same rights as the employer. There's a contractual relationship between the employer and the insurance company. I mean, certainly if the insurance company didn't abide by the terms of the contract of insurance with the employer would have a cause of action against the insurance
Are
company.
you making a claim on its face or as applied? I mean, don't we have to look at it as applied first before we do on its face? Because as applied, we have to look at it in the workers' compensation context. I mean, if the statute's unconstitutional on its face, that's a different issue.
Well, I think it's separate from and forgive me if I'm not answering your question specifically, but I think it's totally separate from the workers' compensation scheme. So I think the statute is unconstitutional.
No, but your constitutional issue, do we have to look at it as applied or on its face? I mean, which argument are you making?
I think it's unconstitutional on its face and then in its application.
Don't we have to look at it as applied first before we look at it on its face?
I'm not familiar with that. I'm sorry. I think that we would assert that it's unconstitutional on its face because it provides absolute immunity to insurance companies.
But the real issue, I think, is does this absolute immunity in the statute apply in the workers' comp setting? It may not apply outside workers' comp. I mean, supposing I'm the FedEx guy and I happen to be on the premise and I end up suffering a toxic tort because I was exposed to fumes or something like that. That wouldn't be a workers' comp claim, and the immunity may or may not apply, I guess. But the real question, I think, is whether this immunity can constitutionally be applied in a workers' comp setting where this grand bargain, whatever the scope of the grand bargain is present.
Well, right, and again, we're arguing that 517 is obviously separate from the workers' compensation scheme, and it cannot.
Is there any legislative history that would kind of support that? I mean, it's located, I understand it's located in a separate part of the code, but functionally, it seems to be part and parcel of workers' comp. Tell me I'm wrong.
Well, I think that the cases, I think it was Fabricius and Bowen versus Kaplan, those are the cases that actually dealt with the predecessor statute to 517.5, and from my reading of the legislative history, that this sort of enactment of this absolute immunity provision, and then when the legislator took it away and then reenacted it again, it wasn't in response to a change in the workers' compensation scheme, but it was in response to the courts, the rulings that came down from the courts. And so I would say on that basis as well, the legislator responded to the cases dealing with negligent inspections. They didn't do it as a part of the workers' compensation scheme.
What's the suspect class? Why isn't this just merely economic regulation that would be treated as reviewed under a rational basis test, regardless of whether it's connected to the work comp?
Well, the suspect classification, and we've identified two tortfeasors. On one hand, private insurance companies are given absolute immunity. On the other, state inspectors are given something less, perhaps qualified immunity. So that's the suspect classification that we've named. The reason that
Is there a decision of our court that says tort claimants are a suspect class that triggers higher scrutiny?
No, what triggers higher scrutiny is the claimant's access to the court system. So there is no other means for the appellants to achieve a remedy against the insurance company other than through judicial process. And that's distinguished from the Sahag case, which analyzed equal protection and scrutiny in this context against the employer, and then said, look, we're not going to apply strict scrutiny in that matter because there is another means, which is the workers' compensation scheme. This is different. This triggers strict scrutiny because there is no other means to achieve remedy except in court against the insurance company.
Well, isn't an employee that is not covered under workers' comp also excluded from the courts to bring a challenge against an inspector?
an
under the
employee that,
statute?
an employee that's not covered under workers' compensation. All employees should be covered under the workers' compensation policy.
All right, well, let's say that it's not, or it'd be an independent contractor or whatever, but how are employees covered under workers' comp separated into a class that's different than others?
Well, if you look at it from the employee's perspective, I mean, first of all, I think you can look at it from the tortfeasor's perspective, because it's the privileges and immunities clause, number one. I mean, admittedly, the court has looked at more privileges in this context than it has in immunities. And so you can look at it from that perspective, and the court did that in the Sahag case and the Sievert versus Resident case. But it's just simply the other side of the coin. So plaintiffs who are employees and covered under workers' compensation on one hand can sue state actors, but on the other, they can't sue private insurance companies. And this sets up the disparate treatment under the statute.
Okay, thank you, counsel.
Thank you.
Mr. Duffy?
Your Honor, may it please the court. My name's Keith Duffy, and I'm here on behalf of the insurance company of the state of Pennsylvania, or as it's referred to in our briefing, ICSOP for brevity's sake. I want to start right where we sort of picked up or left off, was with the idea of there being a suspect classification. And first of all, the statute 517.5 itself says that no inspection of any place of employment shall be the basis for civil liability. So we actually don't see any classification between employees and non-employees. So there isn't a classification.
How do you make the grand bargain argument if it applies to everybody? Even a third party on the employer's premises would not be able to sue the insurance company for negligent inspection.
Certainly, Your Honor. And the fact that it has more than one impact means that it still can be a part of the grand bargain, because the grand bargain here that we refer to, I agree, is the workers' compensation insurance, and that specific breed of insurance is implicated in the grand bargain. So the fact that you may have other kinds of insurance doesn't eliminate the fact that a workers' compensation carrier is still part of that grand bargain. And you do have, I would disagree with the idea that state inspectors are somehow part of the class that would fit in here, because you do have a difference in the group of state inspectors versus insurance company inspectors. Insurance company inspectors and the companies that they work for face liability on workers' compensation claims. They are named as parties in those workers' compensation arbitration proceedings. If a state inspector negligently inspects a workplace or fails to inspect a workplace, there is no consequence of increased claims brought against that employer. Whereas if you have an insurance...
Why are they named as parties? I mean, the Workers' Compensation Commissioner makes them named as parties. I don't think the code does.
The code does not.
And the problem is that the code only makes the employer liable. And I think, I mean, my understanding is the Workers' Compensation Commission wanted to make the insurance company a party to verify insurance and for other reasons, not for the liability purposes.
Well, first of all, the code, by implication and by authorizing the Workers' Compensation Commissioner to make those rules that require the insurance company be made a party, the code does implicitly authorize the carrier to be made a party due to the rulemaking process. But also, employers are either required to qualify as self-insured employers or to obtain insurance themselves. So the code requires that there be some sort of insurance or the substantial equivalent of insurance in place.
Let me walk you through a case that wasn't cited in the briefs, but drew my interest. Now, to be fair, I'm going to try and lay out what the case stood for. But there's a case out of Wyoming, maybe you're familiar with it, Mills versus Reynolds. And the issue was a little bit different. The issue was a workers' comp claim, complete immunity for coworkers. Now, the Iowa allows gross negligence, obviously, but this statute had complete immunity for coworkers. The Wyoming Supreme Court basically said, where you regulate a right of action, that's subject to a rational basis test under equal protection. But where you eliminate the right of action, then it's subject to strict scrutiny. And I think I want to combine that then with our Gaki case a little bit. I think you're familiar with that one at least. And in Gaki, there was considerable language at least talking about the absolute nature of the immunity in that case, and that it eliminated access to the courts. So it seems to me, I'm working with Mills and I'm working with Gaki a little bit, and it seems to me, at least under that framework, the suggestion is where you completely deprive someone of a cause of action against your client. There's no way around it. There's no gross negligence against your client, I don't think. So where you completely eliminate the claim, then strict scrutiny ought to apply.
Well, first of all, I'm not familiar with the Wyoming constitutional provision that was at issue in that case, so I can't comment as to how the different language might interplay. But second of all, the Iowa case law is clear that you can eliminate a cause of action, and as long as the cause has not vested, the cause of action has not accrued, you can make substantial changes to the common law without running afoul of the due process clause. And
You can do substantial changes to the common law, but isn't there a distinction, and maybe not, but isn't there a distinction between complete elimination of any claim and some kind of regulation of the claim? Indeed, the grand bargain in workers' comp is probably the paradigm of a regulation. It didn't totally eliminate a remedy. I mean, workers get some remedy. It's chiseled down a fair amount. But then, of course, on the other side, the employers trade off and so forth. But the fact that that I believe the statute absolutely shuts down claims. Well, unlike, by the way, I mean, Justice Wiggins was working on this a little bit, but if a coworker does a bad inspection, there might be liability for gross negligence. I think you agree. But if a insurance company comes in and does an inspection that's grossly negligent in the same way, there's no liability. And doesn't that give rise to some pretty serious problems?
No, Your Honor, and I would say 517.5 does not actually completely eliminate any liability on the part of the insurance carrier. The second part after the semicolon in the statute expressly states that the provision relates only to liability arising out of the inspection. So it's regulating the nature of liability. It doesn't deny liability for the workers' compensation benefits.
That's correct, but the distinction that does result is that a grossly negligent inspection performed by an employee, you have a cause of action, but a grossly negligent inspection by the insurance company, you don't. And that seems problematic.
That's because the grossly negligent inspection by the co-employee is an employee, obviously, of the employer, and the employer has control of this site. You see a different situation when you look at an insurance company, which does not control the job site in the same way the employer does. The employer has selected who's going to be in charge of the job site day to day. The insurance carrier doesn't actually have that same control, which would warrant the different level of immunity and the different type of immunity that's provided to the insurance carrier in Iowa Code Section 517.5.
What's the purpose of that statutory immunity?
The purpose of this statutory immunity is the same purpose that you find for all statutory immunities that are contained in the Workers' Compensation Code, 8520 specifically. And that is to create, as again part of the grand bargain, an expedited, efficient system to deal with workplace-related injuries that gives employees rights they would not otherwise have to get medical care and some wage replacement when they're injured, even through no fault of the employer, and at the same time takes some of these claims out of the general tort system. And this court has recognized that that is a legitimate state interest.
Let me suggest another possible reason for having this. Insurance companies providing workers' compensation insurance, they have to pay money. That's something they have to do. How much inspection service they want to provide is kind of a voluntary activity. The legislature could have concluded that it would promote more of this kind of inspection activity by granting the inspections immunity, because the insurer's on the hook for the claims anyway, so they already have an economic incentive to help provide a safe workplace. Comparable to that is the medical peer review privilege, which you didn't mention in your briefing, but which essentially gives doctors who serve in a medical peer review function absolute immunity unless there's actual malice, which is a very narrow exception. And there too, the doctor is liable for their own malpractice, but the state may have well concluded it wanted to have doctors encouraged to also serve in this advisory function to do comparable to what they might want insurance companies to do in the inspection realm. Isn't that also a possible justification?
That's correct, Your Honor. There are multiple immunities that are granted and taken away by the legislature as the legislature sees fit to advance various goals, various policy goals that the legislature seeks to advance.
All right, so the legislature wanted to advance policy goals in GACI, and we said no, right? And the reason we said no, I'm going to paraphrase the case a little bit, but the reason we said no is that the immunity statute made it impossible. It was absolute, was part of the language used, that there was, it didn't use the term access to the court, but that you couldn't file any kind of action. And we struck it down.
GACI involved real property rights and involved the ownership of real property, and the right in that case is very different than this one. These plaintiffs were not employees of TPI at the time that the legislation was passed. They were not injured at the time that the legislation was passed. This was a substantive change to the law that occurred in the 1970s. And so they did not have, unlike in GACI, a vested right to bring their cause of action. And that, if I may, goes back to the argument that was asserted about the access to the courts. And as this case shows, these plaintiffs have access to the courts.
Not against your client.
Not against my client for the particular claim that they are asserting. Now, they have already had access to the workers' compensation system and have brought...
Access to a remedy, if you will. I mean, the remedy is whatever the workers' comp would pay out.
Correct. They've had access to the courts and they've had the remedy. Now, what they are actually claiming is that the fundamental right is the right to bring a negligent inspection claim against someone else's insurance company. And that is not a fundamental right anywhere that I've seen articulated by this court or any other. And so the fundamental right, and the Sahag case actually does a good job of distinguishing this when the court draws the distinction between divorce, which was a fundamental right, which was impeded for indigent filers by having a filing fee, and bankruptcy, which is not a fundamental right, and thus a filing fee was perfectly permissible. And so in this case, it's not access to the court, it's having a meritorious claim to bring once you are in the court.
If we don't find your grand bargain argument persuasive, we find that no, the bargain was really cut in 1913, and this is a general statute, and it's really can't be considered part of workers' comp. Where does that leave you?
Where the statute's still constitutional, Your Honor. There doesn't have to be a grand bargain in order for this statute to pass constitutional muster. The state legislature has the power to eliminate causes of action, to modify the common law.
Well, the state legislature has the power to say, we know that in 1857 there was all kinds of causes of action, we abolish them all, and that would be permitted.
I don't know that a statute that broad would be permitted. Actually, it may well be. That's something I haven't looked into, something that broad, but I know when the state or when the legislature sees one particular case, like the Frobenius case that creates a cause of action that hadn't heretofore been recognized based on application of common law principles as they existed at the time, and that was the 1960s, when that case recognized the common law cause of action, the legislature certainly has a free hand to come in and say, no, that's not a common law cause of action under our police powers to regulate, economic regulation. And that decision is one that should be given deference by this court.
What would be the practical consequences if we allowed this cause of action?
First of all, you would see an increase in litigation, you would see an increase in expenses attendant to litigation.
An increase in recoveries, probably.
You may, but what ultimately, and again, in the Seibert case, this court recognized that those costs all ultimately go down to the consumer, because those costs ultimately become borne either by the employer through higher workers' compensation rates, because now, if this immunity is eliminated, we would now see a situation where there is a non-contractual risk that has to be built into the price of workers'
But that's the whole purpose of the tort system. I mean, if you go back and read why we have a tort system, it is to spread, especially when you look at products liability and things like that, you can spread the cost among a lot of people paying a small increase in order to protect the people who get hurt. So, the practical effect is the purpose of the tort system, so I don't think that impresses me very much.
Well, this is the workers' compensation system as well, and we've already recognized that modifications to the tort system are appropriate to achieve the ends of the workers' compensation.
Would there be a powerful incentive to stop doing safety inspections if you could be sued if you make a mistake while doing them?
There would be an incentive to either limit them or limit the scope or put the responsibility for doing them onto someone else. There would be that incentive, and it could result in some of that gamesmanship. But at the end of the day, the workers' compensation carrier is already responsible for workplace injuries, and that gives the incentive they need to ensure safe workplaces. And I see my time is up, so unless there are any other questions, thank you very much, and we ask that the district court be affirmed.
Mr. Duffy, thank you. Mr. Sahag, you may present your rebuttal.
Thank you. With my remaining time, I want to address the appellant's inalienable rights claim. As we've discussed, the appellant's position that their existence of their protected right is the access to the court system. But the second part of the test in asserting whether or not the inalienable rights clause has been violated is whether or not the legislature or the reasonableness of the statute as an exercise of the state's police power. And in Gravert set out what the test was in determining that. And the second prong of that test makes it so that the statute has to be so that the means are reasonably necessary for the accomplishment of the purpose. Now, in counsel's argument, there's some talk about the purpose of 517.5. As I read some of the cases that preceded it, the purpose of 517.5 was to encourage safety inspections to achieve workplace safety. Now, in Bowen versus Kaplan, which is one of the cases that analyzed the predecessor statute, that case said that the claim under the statute, the claim failure to inspect, was not a viable cause of action. So under 517.5, there is no cause of action for failure to inspect. There is no cause of action for negligent inspection. There are no inspections required, period.
But your opponent says, if I may recharacterize it, he says you need to have a vested right, and he says, well, that depends on the timing of the statutes and so forth, and at the time your plaintiffs were employed, the statute was already in place, and that therefore you don't have a quote vested right.
Yeah. And I think your pushback on that was, well, can the legislature just abolish all causes of action? And the answer is no. The legislature can abolish causes of action to the extent that it achieves a permissible purpose or objective, which is right out of the case law. So if the court, the appellant's position would be, if the court deems that this statute is constitutional, it is void, which means it is void from the beginning. And the plaintiff should have a viable cause of action.
I understand you correctly. You do agree the legislature can abolish causes of action for a valid public purpose, correct?
Well, I would argue that they're not entitled to abolish causes of action entirely. And I'm not aware of, apart from the workers' compensation scheme where there was this grand bargain, I'm not aware of a cause of action that's been extinguished.
But it all gets into how you slice the onion, doesn't it? I mean, usually the legislature doesn't say you can never sue X, and it's all a matter of they control and limit and regulate causes of action, and that seems to me is what they've done here. Whether it's constitutional or not, we'll need to decide. But the proposition that the legislature can't alter the common law seems kind of extreme, doesn't it?
Well, that's not the proposition that I'm suggesting. I think they can alter it. They can give you qualified immunity. They can alter the standard of recovery.
Right,
But
so
to
if this
totally
was-
bar it, no.
Your view that if this statute said you can't sue the insurance company unless they're grossly negligent, is your view that that would be okay?
It might be different.
Different, but
Um,
the question is,
well-
would it be okay?
Perhaps, and I think the Alabama case that we've cited in the briefing is instructive on that issue,
Have you alleged gross negligence?
against the insurance carrier. In the
Correct.
petition, no. Back to the means test, in terms of whether or not the statute is reasonable as an exercise of the police power, because there are no inspections required, because there are no conditions upon when inspections should be required. I mean, and because of what had been talked about earlier, but the purpose of the tort system is accountability for culpable conduct, or deterring that type of conduct to make people responsible. It just doesn't follow.
Why isn't it a legitimate state purpose to grant immunity for safety inspections in order to encourage people to do safety inspections?
Well, if the statute actually encouraged people to do safety inspections, perhaps that's what would be the case. But that just simply isn't the case here. There literally is no incentive for an insurance carrier to provide an inspection when there is no inspection required.
Well,
And this
except they-
case is
except they-
demonstrative.
I mean, they want to limit their payouts. So insurance companies often do risk assessments. They vary in quality. Some are somewhat intensive and some are superficial, but under the workers' comp scheme, they're on the hook to pay benefits. They just soon pay fewer benefits, and so there might be some incentive without a tort lawsuit to.
And I see that I'm out of time. May I briefly respond? I think the flip side of that is they might just increase their premiums. Thank you.
Mr. Sahag, thank you as well. Mr. Duffy, thank you again. The case of Clark versus Insurance Company of the State of Pennsylvania is now submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.